meeting commences, I would like to acknowledge that we're meeting on the land of the Bidjigal and the Gadigal people who occupied the Sydney coast, being the traditional owners. On behalf of Randwick Local Planning Panel, I acknowledge and pay my respects to the elders past and present and the Aboriginal people in attendance today. Good afternoon and welcome to this meeting of the Randwick Local Planning Panel on the 8th of May 2025. I'm the chair of the panel and my name is Julie Walsh. Also on the panel today are expert members Kim Burrell and Stephen Davies and community member Kate Kelly. Prior to the commencement of this meeting, all panel members were required to sign a declaration of interest in relation to each matter on the agenda. I can confirm that all declarations of interest have been received and that no conflicts were identified. The signed declarations of interest will be available to view through Council's website by tomorrow afternoon. Do any of the panel members have any further matters to declare? No. And neither do I. We only have one matter in the public meeting today, which is DA 18/25, 1 Mount Street, Coogee. Sorry, it's DA 59/2025. And there are 5 registered speakers. We'll hear first from the objectors and then from the applicant's representative, Andrew Minto. Normally speakers are limited to 3 minutes, but because we only have the one matter on the public meeting today and we only have 5 speakers, I will allow each speaker to speak for 5 minutes. That will be timed, and then I will ask the speaker to wrap up the point that they are making. So the panel has been provided with copies of all of the submissions received in response to the public exhibition of the application. Therefore, there's no need for speakers to repeat all of the points made in those submissions. Speakers should focus on the key matters they wish us to understand and consider, including any suggestions about how their concerns could be resolved. The applicant may wish to comment on issues raised in the Council's report, provide a response to proposed conditions and or address any issues raised by an objector today or in the submissions. After a speaker has addressed the panel members may ask the speaker questions to clarify any matters. Only registered speakers will be allowed to speak and respond to questions from the panel. Any person using defamatory or offensive language may be asked to leave the meeting or the meeting may be adjourned. An audio recording is being made of this meeting and we ask that speakers use the microphone on their device when addressing the panel to ensure that their comments are recorded. The audio recording will be available through Council's website by tomorrow afternoon. After all registered speakers have been heard, the panel will move into closed session to deliberate and vote. So I will now move to the first speaker. Renee De Rossi.
Thank you so much. Good afternoon, everyone. I live at Unit 6 of 2 Mount Street, which is located immediately adjacent to the proposed development. And the report that I can see suggests a minor impact on views from my apartment and that expansive ocean views towards the southeast will be retained, but I have to disagree. At least a third of my view will be obstructed, and my property's enjoyment depends really heavily on this aspect. And it was the reason I purchased the property in 2009 at more than the market rate. And actually in the same year, my apartment was featured in the ABC documentary series, The Making of Modern Australia, ironically in the episode of The Australian Dream. And in that clip, it has my apartment that I recently purchased, and they filmed the view that I get to see every day. And the episode spoke to my grandparents, Italian migrants who worked incredibly hard to afford their own home and supported, in turn, my father and me to do the same. I'm a teacher. I work at a local school in Randwick, and this community is one I absolutely love. And this apartment is very much my forever home. You know, it's not an investment, it's my home. The building's been standing here since 1910, and I think it would be a great shame to take away its prime asset. So, I mean, I can see that the planning principles for view sharing have been considered, although I do really strongly urge further consideration of reduction in the height of the building particularly or in the very least in the areas that are going to block the view, such that the amenity of my property is preserved. So thank you for listening and thank you for giving us a voice.
Thank you. I'll just check, are there any questions? Mr. Burrell, did you have any questions? Mr. Davey?
No, I haven't.
Thank you for coming along today.
Thank you.
So the next speaker is Matthew Powell.
Hi there. Thanks to the panel for allowing me to speak on behalf of Robert and Michelle and Daniels. We're at number 3 Mount Street, which is immediately adjacent to the subject site. So the first issue I wanted to speak about is visual privacy.
Can I just ask you to speak up a little bit?
Oh, okay, sure. So the condition that has been suggested in Council's assessment report that raised the sill heights would essentially equate to 1.6 metres above finished floor level, or privacy glazing screening to windows 30, 31, 32, 33 and 34 is somewhat supported. However, the ability to stagger the windows would provide a much greater privacy protection than the recommended secondary mitigation measures. The rear first floor balcony could also be positioned towards the northern boundary closer to the laneway, which would just bring the balcony beyond the current proposed balcony door. So I just note the assessment report admits that concern is raised regarding potential overlooking from the proposed rear balcony at first floor level. To prevent overlooking to the rear yard at number 3, the condition is included to ensure that privacy screen is provided to the northern side of the boundary. But the assessment report states that properties to the northeast are located more than 30 metres away. This provides a perfect opportunity to reposition the balcony towards the northern boundary, therefore. And in addition, what we would ask for is that the balcony be brought back in line with the rear building line of number 3. Secondly, I want to speak about acoustic privacy. The first floor rear balcony is a major acoustic concern, being so closely located to bedrooms 3 and the master bedroom of our client's dwelling. The DCP does state that noise sources are not located adjacent to adjoining dwellings, bedroom windows. So that's a requirement. But I noticed that the assessment report justifies this by suggesting that, noting that the balconies, I'm quoting, are accessed via bedrooms, not living rooms, it is unlikely that they will be used for entertainment purposes or the like. This statement is an assumption based on hearsay, and if this area was used for entertainment purposes, which is due to the views obtained, then the adjoining dwellings would likely have no acoustic protection. There is actually ample opportunity for noise generation that overflows into these sensitive areas, and we recommend the balcony be reduced to 2 metres in depth and a side setback of 5 metres be incorporated. Then, speaking about excavation, the proposed large-scale basement will require excavation that exceeds the DCP depth control by a whopping 140%. This level of development underground will likely compound the existing stormwater issues by creating less opportunities for soil infiltration in a severe weather event. I note also that if hypothetically the basement were to be removed, the entire house could drop in height theoretically by up to 750 millimetres, leading to a more reasonable Balkan scale. And secondly, related to this point, and this is my last point in relation to stormwater, with the significantly greater than 1 metre proposed excavation sought over the broad area to accommodate the basement, that's including parking, the potential to inadvertently raise number 3's water table and cause localised flooding downhill is a very real concern. And today would be actually a good day if the panel has been out there, I understand, to witness some of these effects with regards to the lack of soil infiltration in the local area. The objective 04 of DCPC 1.4.7 aims to ensure the earthworks do not result in adverse stormwater impacts. This, however, can't be guaranteed to number 3 or other adjoining properties due to the excavation volumes and abundance of hard surfaces. It is noted, therefore, that there are numerous stormwater conditions recommended by the
Thank you. That was the
assessment
five-minute bell. I'll ask you to wrap it up now. Thank you.
Okay. Just in conclusion, we believe that the exceedance of 140% in excavation depth is therefore not substantiated. I'll just hand it over then. Thank you.
Thank you. I'll just check. I had some questions, but I'll just check it. Mr. Burrow, do you have any questions? Do you have any questions, maybe?
No, I have none. Thank you.
Question?
You mentioned a proposal around staggering windows. If you could just explain that a little bit more, that would be.
Yeah, sure. So what we found along the southern elevation was that most of the windows that were in the original proposal, windows 30 through to 34, so there's actually 5 windows there, have not been relocated in the amended plans, and it would actually be possible for someone standing right next to the window to overlook into the adjacent windows of number 3. So our argument is that really there needs to be some staggering of the windows in relation to number 3's windows, because there are quite a few windows, actually all of those windows mentioned have overlap with number 3's windows, including bedroom windows. And in my submission, you'll see there's a table there on page 5 of the response to amended plans, table 1, and that's just describing all of those windows of concern and how they essentially interlock. So essentially we don't see any improvement with regards to the real privacy impacts in relation to these amended plans.
Great, thank you.
Can I ask a question though?
Sure.
Is there an alternative to staggering the windows, or would it be acceptable to have the lower sash perhaps fixed and obscure? I mean, I think they actually may be the window type, maybe one that pivots out, so it may be very difficult to look out through a window that is just opening from the bottom. And if that and the lower sash would be obscure, that would address that concern that you'd have, wouldn't it?
Yeah, it would. However, we're also noting that the size of the windows are really unreasonable for, especially for something that an elevation which is not on the north, so doesn't necessarily need large windows for sunlight capture. But then that would still allow someone standing at the top of those windows, if the size of the windows remain, to have broad overlooking.
So I just wanted to make sure I got down what you said, talking about the balcony of the bedroom on the first floor level. You said you wanted it to be reduced to a depth of 2 meters.
Yeah.
What else did you want done to it?
Yeah, and the side setback to our client's property at number 3 be increased to 5 meters. So effectively the balcony would be pushed to the other side of the property, to the laneway side where there's no adjoining neighbours.
Thank you. I just want to make sure I got that right. I didn't have any. So I think that was everybody's questions. Thank you, for coming along and addressing us today. The next speaker is Timothy Gunn.
No, okay. You can talk now.
Yeah, I represent the residents at 1A Mount Street. I've lived here 28 years and my partner Corinne and I will likely live out our time here. As stated in the DCP, view sharing has regulations. Development proposals must address these regulations as well as the planning principles developed in the New South Wales Land and Environment Court. Important points to be considered are: 1, it is a priority to retain existing views from living areas. 2, existing view corridors are to be maintained. 3, the value of views to significant scenic elements such as ocean, bays, coastline, etc. have to be acknowledged. 4, measures adopted to mitigate potential view loss need to be demonstrated. We believe these fundamental principles have not been met. The DA proposal includes false claims, some of which I now quote: negligible to minor impact on views obtained from neighbouring properties. Additional view corridors may be afforded to these apartments. Quote, continuing, proposed alterations and additions have been designed to protect existing views of the ocean and headland from neighbouring properties. These claims show the arrogance of the developer in pursuit of maximum limits. We dispute these quoted claims in the following ways. 1, the presented view corridors are based on footprints of the existing and proposed building. Hence, no consideration as to the height has been given, presenting a false impression. 2, corrected view corridors and impact of the development are shown in image 1. 3, 1A Mount Street east-facing windows are from dining and kitchen areas and provide the last remaining views of the coastline south to Luline Bay and beyond. 4, due to the height of the proposed roof structure on the east-facing balcony, this view will be severely impacted. 5, the 2 images you see in image 2 show on the left the severe loss of views with the balcony roof. On the right, some of the coastal views maintained without the roof. No effort has been made to address neighbouring concerns. In actual fact, in the amended design, the bulk of the east-facing balcony roof has increased for no obvious reason. Additionally, the ceiling heights have been increased by 0.4 metres compared to the initial DA. In conclusion, we believe the removal of the roof structure of the east-facing first floor balcony and a reduction in ceiling heights to the heights in the initial DA proposed would retain at least part of the coastline views for 1A Mount Street residents and would not compromise the intent of the development. Thank you.
Thank you. Just wait there and see if there are any questions. Did you have any questions, Mr. Malone?
Thank you. No, I have no questions. I understand your arguments.
Do you have any questions?
No questions.
No, I didn't have. No, I think it was very helpful to go and see that this morning. All right. The final resident to speak is Adette Hagan.
Hi, how you going? Thank you so much for giving me the time to speak. I've lived in the street for over 20 years, and as Renee said, it means a lot to me to live there and to have the view as one part of the enjoyment that we all enjoy from those units. So I've just got a few points that I've put together and I'm representing a couple of the tenants in the building with these points as well. So the points that we've identified is view loss. The proposed development is likely to cause a significant reduction in ocean and tree views. The plans are misleading as they base the corridor view on the current one-storey building rather than showing the impact of the proposed 2.5-storey building. Bulk and scale. The height, bulk and scale of the design are inappropriate for this location and out of character with the surrounding streetscape. The building's massing will set a precedent for future developments, risking further erosion of the street's established character. Design and aesthetics. The proposed design, particularly its bulky form and column style, clashes with the existing Art Deco and heritage listed properties in the neighbourhood. I understand from the report that the council's heritage team have approved this, but I respectfully disagree with their assessment, as this proposed development does not fit in with the current street's Art Deco style. Noise impact. We already experience noise issues in the street due to balcony use, particularly in the evenings. This development will exacerbate the problem with multiple balconies, increasing potential disturbance. Basement concerns. We are concerned about the potential impact of the proposed basement on underground infrastructure, including piping and drainage systems. These issues collectively represent a substantial impact on the residential amenity and enjoyment of my property, the broader building and the surrounding neighbourhood. In assessing the development, I request that Council apply the New South Wales Land and Environment Court's planning principles for view sharing, tenancy consulting versus Warringah 2004 New South Wales LEC 140, which emphasise balancing equitable sharing of views, reasonable expectations and impacts on neighbours. In my view, the proposed development's height and scale exceed what is reasonable and fail to properly consider the impacts on existing residents. I respectfully request the Council requests the applicant reduce the height, scale and bulk of the proposed building, and also request improvements to the design to better integrate with the character of the street. These changes would help mitigate the loss of amenity to neighbouring properties, including 2 Mount Street. In closing, I would also like to add that I understand developments are inevitable. However, I would hope for some level of understanding from the incoming residents to respect the current style of our neighbourhood, the neighbours' enjoyment of living, and to take into account why we are objecting. I would also hope that Council would consider the current residents' objections and help us negotiate a solution that supports a reasonable outcome for all involved. Thank you.
Thank you. I'll just check. Did you have any questions?
No.
Mr. Davies, did you have any questions?
No.
No question.
I have no questions either. Thank you for coming along and speaking to us today. The final speaker is Andrew Minto, consultant on behalf of the applicant.
Chair, panel members, yes. So Andrew Minto, I'm a consultant town planner on behalf of the applicant. Panel, we're of the view that the issues relevant to this application have been appropriately addressed within the council assessment report, including those matters raised by the adjoining property owners. We have reviewed the conditions of consent and we are generally accepting of those conditions. Just briefly in relation to a couple of the key issues raised by the adjoining residents. So in relation to views, we believe that that issue has been appropriately addressed within the report. The applicant's view analysis that's included in the architectural plans, it is prepared on the basis that there are no views achieved over the adjoining property. So it doesn't rely upon views over the property. So the height issue there becomes irrelevant. What it demonstrates is that view corridors are maintained to those key iconic items in the view, being Gordons Bay and Coogee Beach, onto the sides of the proposal. The proposal does not impact upon those, unreasonably impact upon those view corridors. Yes, there will be a potential change in outlook over the dwelling, but that view, in our opinion, is not a view which, based upon tenacity, would fall into that the identification of like an iconic view or the like. It's not a view of as I said, one of those iconic elements or a land-water interface or the like. In relation to this issue of privacy in the windows of the adjoining property and this the suggestion of staggering, I don't quite understand that issue in that the proposed windows in question are first floor windows. The adjoining property at number 3 is a single story dwelling. The views, the outlook from those windows are over the roof of that dwelling. I'm not sure what benefit there would be by staggering. They're not located at the same level of each other. It's also worth noting that in relation to those windows, that they relate to 2 bedrooms, an ensuite, a bathroom and a walk-in robe. Obviously the windows to the walk-in robe and the ensuite and the bathroom, the nature of those rooms and their uses mean that people, when they're in those rooms, are going to be after privacy as well. So the provision of some sort of privacy treatment to those is not considered to be unreasonable. The bedroom windows have been designed so that the occupants of those rooms can achieve a view over the roof of the adjoining property in the direction of Coogee Beach. In relation to the balcony change, the balcony's been designed so that its eastern alignment marries up with the level below. It's 2.5 metres wide. I don't believe a narrowing to 2 metres is necessary in this instance. The suggestion that it be relocated further to the northern side. The purpose of the balcony obviously is so that you can gain access to it from the bedroom. Relocating it further to the north is going to limit the ability to achieve that access. So I do not believe that those changes are appropriate in the circumstance of this case. So in summary, we believe that the issues have been appropriately addressed. We're accepting of the conditions and we'd ask that you endorse the officer's recommendation. Thank you.
Thank you. I'll just check. Mr. Burrow, do you have any questions?
I've got a couple of questions.
Yeah.
Andrew, I think some of the residents have said that during the formulation of the application, the amendments that were done, that the height of the building had actually increased. Why was that done?
No, the height of the building has definitely not increased as part of the proposed or the amendments which occurred. So there were discussions. The original application that was submitted to council included a rooftop viewing terraces at both the front and the rear of the building. Access to those terraces necessitated a departure from the height control. In negotiations with council, that upper level roof terraces were deleted and the overall height of the building was reduced to bring the building into compliance with the height control.
Another question, on the southern side, we've got the laundry and it's being served by some stairs going to the front yard and the backyard. I'm just wondering what purpose does it serve?
Obviously with a laundry, it is preferable if you do have external access. It is elevated above the external ground level, so a landing and stairs is necessary if external access is going to be provided. That's its primary purpose, is to provide access from the laundry to the rear yard.
It goes to the swimming pool and then you have to circumnavigate the swimming pool to return to the terrace, where more than likely going to be the place to where you would have a drying area, or you simply go through the house to get to that area a lot quicker. It just seems to be a bit superfluous, and it is elevated, and it's diagonally opposite two windows.
Yeah, no, I accept those criticisms. Yes.
So we could do without those.
I'm not the one that's going to be living in the dwelling, but as I said, I understand your concerns. Yes, I accept that it's, if those stairs and landing were not there, that would remove a potential conflict between the subject site and the adjoining property. Access can still be achieved to the rear yard and the drying court of the lake.
Yeah. We also have an outdoor bathroom on the first floor balcony. Why is there an outdoor bath?
I'm just I'm okay. I can see that structure. Yeah, so it does appear that it is a bath. It's not labelled as such, but I understand that's probably the case. Yeah.
Is it necessary?
Once again, I'm not going to be living in the dwelling. I can see it could be a nice feature to having that dwelling. I don't believe the bath itself and its location is going to result in any unreasonable impacts upon the adjoining properties. as I said, I can see it would be a nice feature if you were the occupant of that dwelling.
And the storage area in the basement, served by windows. You're obviously well aware of, the court's concerns about potentially habitable spaces within basements.
Well, I think the normal issue is with basements is that people provide spaces that do not have appropriate light and ventilation and then seek to use them as habitable spaces. In this instance, the areas are nominated as storage. Yes, they will have some natural light and ventilation. Once again, I think that's probably a positive aspect. I'd rather have a space that does have a window and get some natural light in there. But as I said, the normal issue in relation to basements is that people provide spaces down there that don't have light and ventilation and then seek to use them as habitable spaces.
Okay. That's all.
Did you have any questions, Mr. Davies?
No, I think that my questions have been asked. Thank you. That's
Just the other thing, sorry.
Yep.
We've also got the solar panels on the southern side of the roof. Can they be relocated? Just wondering why they're being chosen to be located on that side of the house. There's no fundamental reason why they're there.
They've got some on, they've certainly got some on the eastern elevation. There's some on the north.
Majority of on that southern side though.
Yeah. What is the concern in relation to that? Just in terms of just their overall efficiency, or
the overall efficiency? And if you're providing them, there's probably the benefit of actually being able to use them effectively would be on the north side.
I agree. If I would have thought they should be located to maximise their efficiency. Yes.
Correct. Okay.
I was just asking whether you had.
No.
I just had a couple of questions. You asked a question whether the height of the building was increased with the amended plans, and you said no because the rooftop viewing platforms had been removed. Were the floor to ceiling heights increased in the amended plans compared to the original plans?
I understand that, yes, there was some adjustment to the floor to ceiling heights as part of that process, yes. But the building was nevertheless was brought into compliance with the height controls.
And I think one of the resident objectors had suggested that if the basement level was removed and a different parking arrangement was proposed on the site, then that would allow the building to be lowered with consequent ameliorative impacts to views to the neighbours. Do you have a comment on that?
Well, it's a completely different development. I mean, if we don't have a basement, then we have to accommodate parking at the ground floor level. The whole dwelling would need to be redesigned. I'm not sure what form that final dwelling would take. But at the end of the day, regardless of that, the building does comply with the applicable height controls, FSR controls, side setback controls, and consistent with the findings of the council assessment report. I don't believe there's going to be any unreasonable impacts resulting from the built form as it currently presents.
So you didn't. That was never part of the site analysis process.
I wasn't the building designer, but at the end of the day, as has been identified, there is a shortage of car parking, available street parking in the area. The owners have desired to provide a basement so that they can accommodate their vehicles, their hobbies and storage of associated materials and the like. I don't believe that there's any detrimental impact associated with the provision of the basement.
The other thing I just want to, so Mr. Powell, on behalf of the owner of 3 Mount Street, suggested that the balcony off the bedroom, the upper level bedroom, be reduced in depth to 2 metres and be set back 5 metres from 3 Mount Street. Did you have a comment on that?
I spoke to that previously, yes. So the existing balcony is 2.5 metres in depth. It's been designed so that marries up with the depth of the al fresco area on the ground floor below that. So the columns are, corresponding with the depth of the ground floor balcony. And then if it was relocated further to the north, that would then make access from the bedroom onto that balcony difficult. It's designed so that so it aligns with the bedroom.
Nobody else had any questions for this speaker? No.
No.
All right. Well, thank you for coming along, speaking to us today. That is the last speaker, and as this is the only item on the public meeting, I now declare the public meeting closed at 1:37 p.m. Thank you.
Thank you.